students. So this is our lecture 2 in the Constitutional Law series of the Clat lecture series sponsored by Sri Jayendra Rank Zone. I am your mentor Shekhar Gehlot. So in the previous class we discussed about Constitution, what is its preamble, and why do we need to understand or study Constitution. Okay. So now in this lecture 2 I would like to discuss how to study the Constitution, how to understand the Constitution of India. Okay, uh, in class 8th, I remember when we started studying biology, we never straight away started with the microbiology. We started with the macro, in which we read about the major organs of the body like brain, heart, lungs, liver, intestine, large, small, stomach, etc. Okay, because in order to understand a structure deeply, minutely, we must first understand it in a broad and basic perspective. So in this constitutional law lecture 2, we will try to have a very basic and broad understanding of the Constitution of India. As you all know, Constitution of India has divided into 22 parts. So all of these 22 parts now have their own individual place and all individual importance, and they all work jointly. All these parts function jointly. None of them functions in isolation. That means when we study Constitution of India, we study it as a whole unit, not in small parts, fragments. So in order to understand Constitution of India properly, what I have done is today I have divided these 20 parts in different groups. And I'll place all these parts in six different groups, and we will try to understand each and every part in part of those groups very clearly. Now let us divide Constitution in 6 groups. These 6 groups are A, B, C, D, E and F. Now we'll read about these groups one by one. First of all, that is Group A, which comprises of Part 1 and Part 2 of the Constitution of India. So Group A deals with India. What is India? So in the previous class we discussed, if somebody asks you to define India, how will you define India, or how will you say something about India? That is included in our Article 1 of the Constitution of India. This is Article 1 of the Constitution of India, which says India, that is Bharat, shall be a union of states. This is the definition of India given in the Constitution of India, Article number 1. India, that is Bharat, shall be a union of states. So now what do we know about India? that India is a union of states. Okay, India is a union of states. It gives a clear picture of the Constitution of India and India as a whole country, that we all people of all states, with all our disparities, come together to make this country. Okay, so the Constitution of India does not say that India, that is Bharat, shall be India, that is Bharat, shall be a country of this much territory or running from this length to this breadth, but it simply says union of states. This is a very beautiful statement added by the founders of the country, which makes it clear that India cannot be an India without its states intact together. Its states means all the people of the states with different language, different culture, different traditions and different backgrounds. When they all come together, then one country is born, that is called India or Bharat in Hindi. Now, part 1 runs from article 1 to 4. Part 1 runs from article 1 to 4, and the broad discussion in this part 1 is about India and its physical structure, that is how to add or delete a state. Yes, Constitution of India does discuss about a procedure where it can add or delete a state from India itself. Okay, it may be very surprising to you, but it has been actually used a lot of times, couple of times, like Goa. It was added in India in 1961. Similarly, Sikkim was added to India in 1975. These countries, Goa and Sikkim, they were not originally part of India, but they were later acquired. Okay, so we later acquired these territories, and they became part of India. That is how we add a state. However, we have never deleted a state till today from our Indian borders. How to alter the boundaries of the state? So boundaries of the states can be altered, like can be modified, can be split, can be merged. So states can be, India can add 2 states and make a 1 state. Okay, or India can split 1 state into and make 2 states. Okay, or borders can be changed. Okay, naturally when any of these action will take place, split or merger happen of the states, borders will be modified. Very recent example is Andhra Pradesh and Telangana state. This state was a new state. Telangana state was carved out from the Andhra Pradesh, or after revision of Article 370, now Jammu and Kashmir has become a union territory and Ladakh as a separate UT now. Earlier, Ladakh and Jammu Kashmir was part of one state called State of Jammu and Kashmir, but now using this provision, which empowers Union of India to add or delete or alter the boundaries of state, the state of J&K has been bifurcated into 2 separate units. One is now J&K Union Territory, other is Ladakh as a separate union territories. How to change states into union territories and so on. This is the power provided by the Constitution of India to the Parliament of India in the part 1, that is Group A, that is India, which includes two parts, part 1 and part 2, group A. And the part 2 of the constitution discusses about the citizenship. Okay, now any country other than its borders or other than its area is also known by the people, its citizens, its occupants. So what is citizenship, how it has to be acquired or given up is dealt with in the part 2 of the Constitution of India. Okay, so it deals with how citizenship can be acquired. Now, as of now, as per the Citizenship Act, there are different ways of acquiring a citizenship. Acquiring a citizenship of India, like by birth, if you are born to any Indian citizen. Okay, if either of your parents is Indian citizen and you are born to them, by birth you will be Indian citizen. By descent, born outside India but to an Indian citizen. Now suppose two people are working outside India, okay, and two, like one Indian and one US citizen marry and reside in US. Now the baby is born, now the child is born. Then this child can now acquire Indian citizenship by using this clause, by descent. He or she could claim that because when I was born, one of my parents was Indian citizen, so I am eligible to be made Indian citizen. Or by registration, when you make an application Union government for conferring citizenship upon you. That is called the process of registration. Very famous example is Sonia Gandhi. Mrs. Gandhi acquired Indian relationship by way of registration because she married an Indian citizen, that was Mr. Rajiv Gandhi. And then naturalization, that is, naturalization is a process which says that you are so Indianized that citizenship could be granted to you. A person who has stayed in India for such a period of time that he has become so much Indianized, he has become so familiar with the India, its language, its culture, its tradition, and he has acquired some government job or a regular job in India and has stayed for a quite duration of time, so he can apply under this process of naturalization, or when we acquire new territory. When India as a country acquires a new territory, like we did with the Goa or Sikkim in 1961 and 75 respectively, those people who are part of that territory now become Indian citizens. Automatically they are given Indian citizenship. These are the ways of acquiring Indian citizenship, and then this Indian citizenship could be lost as well. Okay, this is also provided by the Constitution of India, that how Indian citizenship could be lost. One is by renouncement. When you renounce your citizenship with India, when you yourself voluntarily give up Indian citizenship, your citizenship will be lost by the process of renouncement or when you accept some other countries. When you accept some other country's citizenship, your citizenship of Indian country will automatically be lost because India doesn't allow holding of double citizenships or by forfeit. By withdrawal, Indian country can withdraw your citizenship as well. How can it withdraw your citizenship or recall your citizenship? We will better call it recall. When a citizenship is recalled, like when you applied for the Indian citizenship under any of these clause and you used fraud with the papers in taking the citizenship and that fraud is now come out and alive, then your citizenship could be recalled or could be snatched away from you by using this particular process by the government of India. Now we proceed to our group B. Goals of India. First is our group A was what is India. Okay, now we go to now when we know what India is. Okay, what India is and what is its composition. Now we go to goals of India. When we have a country, okay, then we must have some goals as well. We must have some goals of that particular country which one country strives to achieve, and this is very relevant. This is very relevant because India is a very new country. Okay, merely 75 years old, which is not a very big time span in terms of a country's age. Okay, so why do we need goals of India? Because that is what we fought for. Okay, our freedom fighters laid their lives for the service of this mother country so that we can have this particular part with us. Okay, so that we can have this particular part with us. Okay, it is not that when the country was a British colony, we did not have lives. We Indians never lived, or they did not have trains, or they did not have newspapers, or some other facilities. They have almost all, many facilities which were standard at that particular point of time. But we still struggled hard to achieve our independence because we did not have these things. That is the goals of India. Okay, the goals of India is fundamental rights. We did not have fundamental rights. So this is the goal of this new country. We just come out of the shackles of slavery. That now when I have come alive, I have come out and I have become independent. It is my goal as a country to provide all these fundamental rights to my fellow citizens which were not available to them earlier when I was a slave country. Okay, we have everything under British dominion, but we never had these fundamental rights. Okay, what are these fundamental rights? We'll discuss them in detail later on in next chapters, but these are very basic rights. Basic rights can be called human rights as well. Okay, so fundamental rights are those rights which are very much relevant for basic development of a human beings and which are inalienable, which could not be taken away from a human being. And if these rights are snatched from a human being, human dignity will be lost. Okay, so this is what we did not have. We did not have this thing called human dignity when we were slaves, because we did not have these fundamental rights. That is why our freedom fighters fought for the independence of this country. Almost 250 years old struggle went on. So many people laid down their lives, so many struggles, so many movements, so many natural calamities, and with so much torture borne at the hands of Britishers just to attain this freedom. And what we got after this freedom? We got our right to choose and determine the goals of the India. The goal of India, first goal of India is in the part 3, that India shall provide fundamental rights to its citizens. Okay, so what fundamental rights are? Those basic rights without which human dignity will be lost. They are also sometimes referred as negative rights. Why negative rights? Because no energy required at all. So they came into effect immediately.
It's 9 o'clock.
Okay. Negative duties. In implementing fundamental rights, no energy is required at all. Suppose let us have example of right to equality. Right to equality. Now in this right to equality, government wants to ensure equal treatment to everyone. Government is not supposed to do anything. Government is not supposed to do anything. Only thing the government is supposed to do is do not discriminate. Okay, by not doing anything, by not discriminating between the citizens, between the people, the right to equality will be implemented. Government doesn't have to do any special thing. They don't need resources. Only thing is they have to treat everyone equally and with dignity. Or let's say example of freedoms. We have freedoms under Article 19, like freedom to expression, freedom to assemble, freedom to carry out trade and profession, freedom to venture through the country. So in order to ensure that all these citizens of India enjoy these freedoms fully, government is not required to do anything. Okay, government is not required to spend any energy at all. Only thing government is supposed to do is that they just don't interfere with the rights of the people, basic freedoms of the people. That is why they are also called negative duties, and they are also called negative duties as well, because these are guarantees. These are the guarantees, or these are the, what I may say with a better word, these are the like assurance given by the Constitution of India, that these rights shall never be taken away by the states. These are negative duties upon the government of India, that government of India shall not, okay, the word is shall not. This is the word used in the many of the fundamental rights, that government shall not do this, government shall not discriminate, government shall not take away, government shall not deprive. Okay, so government shall not, government must not. Okay, so that is why they are called negative duties, a duty which government does not have to do anything. Okay, negative duties, and doesn't require any resource at all. That is why they came into effect immediately, that is when the Constitution of India was implemented on 26th January 1950. These fundamental rights came into effect immediately with the onset of the Constitution of India. Now, other part is within the goals of India. Other part is part 4 is the directive principle of the state duties. Okay, now this is means directive principles means guiding principles or guidelines which states have to follow in fulfilling their duties. Now every state has a duty towards its citizens or the people residing in that particular state. Suppose if I talk about the state of Delhi, Delhi has a duty nowadays, when because air pollution is very rampant and very heavy, very obnoxious in the state of Delhi. So the Delhi government has a duty to keep a track on the pollution levels of the country, of the India, of the Delhi, and how to reduce those pollution levels. Okay, and how to keep those air levels in such AQI quality index that it doesn't harm the health of the people. So these are the directive principle of state duties. So whenever state is performing a duty, these are the guiding principles which state has to follow. However, these are only guidelines which state ought to observe. Okay, it's not state must observe. These are those principles which our founding fathers thought that state should follow. They should take light from these guidelines, but they were not made. These are non-justiciable. Okay, but they were not made. Non-justiciable means for which you cannot go to the court. Non-justiciable is something citizen cannot go to the court for enforcement. And fundamental rights, they are justiciable. Any citizen could reach to the court for the enforcement of fundamental right if they are not provided or if they are not enforced in the proper manner as enshrined in the Constitution of India. But directive principles of the state duties or policy, the correct word is policy. Directive principle of the state policy. Okay, this is one such thing in which these are non-justiciable. Citizens cannot go to the court for implementation of DPSPs. Why is it so? Why is it that fundamental rights are kept justiciable and directive principle of state policy kept non-justiciable? Only reason for this is because fundamental rights are at most important, plus they require no resources at all. Like we discussed, state only needs to do one thing, it doesn't need to do anything. Okay, for implementation of fundamental rights, states does not have to do anything, it just have to sit back and treat all the people equally and the fundamental rights shall be guaranteed. But in implementation of directive principle of state policy, which in short form we call DPSPs, these are, it requires huge resources like lands, funds, employment, time, etc. Therefore they could not be made enforceable at the time of the independence of the country, because country was very poor country, or I won't say very poor country, but country was not in a position to ensure all these fulfillments or all these resources available to the citizens in earliest point of time. So fundamental constitution framers thought that we must give time to the government so that it can amass resources, it can have lands and funds, and so that it could generate employment and achieve all those ideals which could be delayed for the time being. So it requires huge resources to build a hospital or a college or an education or some other institution. So that is why, so that citizens could not reach to the court claiming that they should have a hospital in their state or their district or their village, or they should have an engineering college in their village. Okay, because state will be very heavily bound and country would not be able to tread forward. So these DPSPs are called kept non-justiciable, and these are only guiding principles. Okay, now we have new article added to the Constitution of India, that is Article 21A, which is right to education. Okay, it gives right to education to all students till the age of 14, compulsorily, free of cost, and state is duty bound to provide these rights to the students. This is a dream come true of the Constitution of India, because it is a part of, earlier it was a part of directive principle of state policy, that state should strive to provide free education to students, children till the age of 14. Now it has become a right. Now this DPSP, which earlier was a DPSP, has now transcended to become a fundamental right. Why? Because now country feels it proper that now we have attained enough resources that now we can make this part a fundamental right. So students, now when the country is giving us so many things, it is giving us fundamental rights, it is also trying to obey certain principles which are called directive principle of state policy for development of the country, and country is spending so many resources, then we as a citizens also have some duties to perform. We also do something for our own country, and these are fundamental duties which constitution framers thought that these fundamental duties are which citizens could do, at least the basic thing which citizens could do for the country. Okay, these are called FDs in short. They are also non-enforceable. Okay, they are also non-enforceable, or may say non-justiciable. Okay, because it requires basic common sense, which is very rare nowadays. Okay, or which has always been rare. Okay, it's fundamental duties like we have to respect our women, we have to have a scientific temperament, we must maintain our ecology and the wildlife, and we must respect the national emblem and the its emoluments. Okay, and we must maintain the environment, we must strive to have a better friendship with the foreign nations, and so on. Okay, so though these duties are very basic in nature, like we can say respecting a woman is a very basic duty and which we all must do in any case. But however, countries like that, it takes a lot of time, people are different in number, a great number of population is there, so that is why these duties are not made enforceable, so that there are no chaos in the country over non-performing of duties by someone, or so that this particular clause is not used by the state to sabotage any opposition or sabotage the people, so that government doesn't run after the people for non-fulfilling their fundamental duties. Okay, and constitutional framers thought that people would gradually understand their duties. Okay, so people, it would eventually grow upon the people, so it takes time, that is why. These are some fundamental duties. Okay, we'll do them, we'll do these fundamentalized TPSP's fundamental duties in detail when we go into the in-depth analysis of the Constitution of India. Now, when we have a country which has its goals, okay, when we have a country called India and India has its goals, then we must have means to achieve those goals as well. Okay, merely having goals is not sufficient in itself, we must also have means to achieve those goals. Okay, but means must be moral as well as constitutional. Okay, that is why these means have been prescribed in the Constitution of India, that is why the means have been written. Okay, because goals could be achieved from unconstitutional and immoral ways as well, but that is not what India or the fabric of India is, that is not what our country is. Our country has always followed its moral grounds and has always demonstrated highest constitutional values in both national as well as international affairs. Why? Because these moral and constitutional means are a part of our daily tradition. We Indians have a history of following these moral and constitutional values as a part of our daily living, as a part of our daily tradition. This is the basic fabric of India as a country. That is why means to achieve goals, these means to achieve goals are moral and constitutional, and they have been prescribed as well, so that tomorrow no future generations may try to tread any other path than the path which is moral and the constitutional. Okay, so these means run from part 5 to 19, quite elaborate. Like I discussed, we have 22 parts in the constitution, and out of those 22 parts, almost 75% portion is consumed by the means to achieve those goals. Okay, these are part 5 to 19. We'll, for a moment, we'll skip this particular portion We'll come back at it in the last part. First of all, now we go to another part of the constitution. That is part D, sorry, that is group D. These are groups, group D. Okay, group A India, group B is goals of India, group C is means to achieve those goals, group D is amendment. Okay, now we have a country. Okay, country has its goals. Okay, and now the country has the means to achieve those goals as well, which is in part 5 to 19, which we'll do after some time. So now the country and the setup of the country is complete. Okay, we have a country, goals, and means achieved as well. But our constitution is not only the lengthiest or the written or the most in-depth constitution of India, but our constitution is very much flexible and dynamic constitution. Keeps up with the time, never grows old. Our constitution is forever young. It always keeps track of the time. It's a very dynamic constitution. Dynamic constitution means which changes with the time. It is not a rigid and a dead document which has lost its relevance. Okay, why? Because we have this particular group, or we have this particular part in the constitution of India, that is part 20, which says amendment. Amendment means, as the word, normal word suggests, this means modification, alteration, or change. Okay, so our constitution framers thought that now we have crystallized these, what India is, or what are the goals of India, or the means to achieve those goals. Now tomorrow, suppose, see, this constitution was framed in 1950. Okay, so they thought that suppose sometime in 2020, India as a country needs some new, there are some technological advancements, there are some new rights available to the citizens across the country, or there are some newfound duties which government ought to observe, or there are some new changes which country has to follow in order to keep it updated all the time. Then they gave this portion to the Constitution of India, that is called amendment. Okay, or tomorrow, if our goals are achieved, suppose these goals are achieved, then what do we do after that? After achieving the goals, the country shall not stop, country shall always keep going on. Okay, so we should not become redundant. So when the new situations come up, there may be a way to make necessary changes in the constitution, that is called amendment. Okay, I can only summarize by saying that the constitution framers built a structure. Okay, they built a structure and put all the things in the place and locked it. Okay, like they built a very big building, they put all the pillars, all the furnishings and everything there for a comfortable stay for next 40-50 years, and put a lock over it. Okay, and then they gifted the key to the people of India. Now they have finally closed our constitution in 1950 and put a lock over the constitution, but they have given the key to open this lock and make changes in the constitution of India to the people of India, and they have left it to the wisdom of the people, and as per the wisdom, people of India over the time could make various amendments and changes to the constitution of India. We have already seen more than 100 amendments to the constitution. That is why our constitution is very dynamic and it never grows old. Okay, now after part D we go to part E, that is interim and special provisions. Group E, interim and special provisions, that is part 21. Okay, what is this interim and special provision? See, when the constitution came up, it came up in 1950. Okay, like almost 75 years, 70 years back it came up. Okay, So, but when constitution came up, we elections had not taken place. We did not have a parliament. We did not have a building to have Supreme Court of India. So many high courts were not there, and IAS, Indian Administrative Services, were not there. IPS services were not there. General elections had not happened, and so much new had to be done, and so much of the paucity, so much of the area where we were lacking was there. Then how do a country function without having a proper framework for the judiciary or elections or proper working parliament or the IAS? Okay, for that matter, executive was not there. So how do a country as large as India function? That is answered in the interim and special provisions. Okay, now in the constitution. Okay, so in order to make the transition from pre-constitution India to the post-constitution India very smooth, we had this interim measures. Till the time we did not have all these functions operating, all these features operating, we had interim features which used to operate. Okay, till the this gap or vacuum was filled. Now we can say this is one part of the Constitution of India which has now completed its purpose. Okay, because it had a very limited life. Now we have everything in place. Now we have general elections, we have Election Commission of India, IAS, IPS, so many commissions, so many secretaries. Now we have everything, all functional, fully functional, three, four pillars of the democracy. So now this part, if somebody asks you which is the part of the constitution which has lost its relevance now, we can fairly say that this is the part which has completed its purpose, that is interim measures, because now we no longer we no longer need these interim measures. And then there are special provisions. Why special provisions? Because see, India has such a vast boundary, okay, such a vast area. We stand seventh in the terms of sizes, land size in the world. We have so many disparities, like we have Jammu and Kashmir, which has been a very troubled area. We have northeastern areas which are very full of very indigenous people, okay. Then we have different traditions, we have cultures, okay. So these are those countries, okay, those people which are those areas which are disturbed or which are full of indigenous people, okay, which are not too much akin to the city life. So we have to keep some areas specially and differently, we have to treat them differently. These are special provisions in part 21 for these areas, okay. Now removed Article 370 was one of such special provision which was provided in part 21 to the state of Jammu and Kashmir, which has been now taken away. Okay, Manipur and Andhra Pradesh, okay, to make the life more peaceful and civil, constitution framers thought that some areas need more attention than the other areas. That is why special provisions for these areas. Now we go on to the last part of the constitution, last group of the constitution for the parts of the constitution, that is introduction of the constitution. That is the last part of the constitution, part 22. Okay, now if somebody knows you, if somebody asks you where you know that it came into, like I said that our constitution came into effect on 26th of January 1950. Now if somebody asks me why do we call it Constitution of India, why not India's constitution or Constitution of Bharat, one Bharat's constitution, why Constitution of India only, and why, where can you tell me from that it came into enforcement on 26th of January, not on 25th or 27th? Then I can refer to this part 22 of the constitution. This is introduction to the constitution. This is the part which will provide you all the basic details about the constitution, that it came into effect on this state and this shall be called Constitution of India, and all this is the introduction part of the Constitution of India. So now we have divided, we have dissected the 22 parts of the constitution into 6 different groups. I am just trying to give you an overview of what we studied today. We have divided into 6 groups. First, group A deals with India, what is India and its citizens. Okay, a country becomes from a country is known by its territory and the people which inhabit in that particular country. So that part is part A is dedicated to group A is dedicated to India and its introduction. Then group B, which includes part 3, 4, 4A, what are the goals of India, what India seeks to achieve. Then group C is means to achieve those goals, which we'll find in part 5 to 19. Means to achieve those goals, we have to have some means to achieve those goals. Okay, then we have part group D, that is amendment, part 20, that tomorrow if we need some change, that how to make a change in the constitution of India, it has been provided in this particular part 20. Then group E is interim special provisions, which part 21 deals with. Then in the end we come with the last part of the last group of the constitution, that is introduction to the constitution, that is part 22. Okay, now we'll understand sub parts of this particular group which we kept for the end. Okay, so there was group C, which talked about means to achieve those goals between part 5 to 19. So this part 5 to 19 has two kind of means. Okay, two kind of means to achieve those goals. First is direct means and then other one is indirect means. Okay, now I'll do one thing, I'll go to them one by one. Okay, first is you need to understand we have direct means to, out of part 5 to 19, part 5 to 10 talk about the direct means to achieve those goals. What can be a more direct mean in a country to achieve something than straight away the government? Government is the most direct and immediate means to achieve something, achieve a goal. Okay, achieve a country's goal. So we have, how many types of government do we have in India? We have more than 7 types of the government in India. Okay, now you must be understanding that what I'm talking about, you must have heard only about 2 types of government, union and the state, but I tell you we have a center. Okay, we have a central government. Okay, now when I talk about the central government, okay, I talk about parliament, executive, central executive and union judiciary as well. Okay, these all three, which when they come together it becomes government. Okay, usually parliament or the legislative members or member of parliament, these people are used as a synonym term with the government. No, okay, the actual meaning of the word government is parliament, executive and judiciary all together. Okay, so first form of government, first type of government which we have in India is the central government, which includes parliament, executive and union judiciary. Part 5 of the Constitution of India deals with the first type of the government, that is central government. Then we have a state government. State government again includes high courts, state legislature assemblies and state executives. Part 6 deals with state. Then we have union territories. Okay, they are also having their own separate format of governing, where half of the portion is done, role played by union territories government, half role is played by the central governments. Okay, now then we have panchayat government. Okay, government at the panchayat level, which is bifurcated into 3 levels: village level panchayat, block level panchayat, and district level panchayat, which is in part 9. Then we have municipal government. Okay, municipal government is the another form of government which functions on the in the urban areas or municipal areas. Like we have uh, Municipal Corporation of Delhi (MCD), or we may have Brihan Chennai Corporation. Then we have cooperative societies. Yes, cooperative societies are also a part of government, and they are a separate kind of government. They have their own governance. Okay, the very big example of this is Amul, Amul India. Amul India, for which we have a lot of milk products and ice cream products, usually dairy products. Amul, a big manufacturer, not manufacturer, a producer. Okay, so that is a cooperative society. They have their own separate governance. Then we have scheduled tribes and scheduled areas government. Okay, so now we have more than 7 types of government in the India, and these are the direct means to achieve those goals, and it runs from part 5 to 10 of the Constitution of India. First is central government, state government, union territories, panchayat raj government, municipal government, cooperative societies, and then administration of scheduled tribe areas. Scheduled tribes. Okay, why? Because these people, simply because these people, they are special people and they need special care. They are not very cunning or very like developed or very forward like a very normal rural or normal urban people. They have their own setup, their own linguistic setup, in ingenious setup. They have their own boundaries out of which they never come out. They have their own facilities. So in order to keep these people, so that normal people does not cheat these people or does not incite them into doing something which they ought not to do, because they have a different set of culture, we have a separate administration of scheduled tribes areas. Okay, they are directly administered by the government or the directly administered by the governor or the president of India. Then we have interrelations. Okay, part 11 to 13. Part 5 to 19 we are discussing. 5 to 10 are 7 types of government. Then part 11 to 13, that is center state relation, which is very detailed one, but which the details of it is not relevant for our syllabus right now, but a brief understanding is, because center and state may have differences. Okay, because central government has its own property, state government has its own property, central government has its own lawmaking power, state government has its own lawmaking power. So there may be so many times a difference of opinion, or there may be friction between a center and a state. So how to handle that friction, how to ease out those differences, how to make the working between center and state, like division of taxes, okay, separation of the tax collection, distribution of the collected tax between center and state, how to take care of these things, that is dealt with in part 11 to 13 of the Constitution, which is usually called interrelations between center and state. Then there are, when we have direct means to achieve those goals, we have some indirect means to achieve those goals. Indirect means are run from part 14 to 19. Okay, indirect means are like establishment of Indian Administrative Services, Union Public Services Commission, Pradesh Civil Services, which is Article 14, CAT, that is Central Administrative Tribunal, election commissions for conduct of free and fair elections, other commissions like scheduled caste commissions, scheduled tribe commissions, backward communities commissions, or women commission, national human rights commission, these commissions, And then language, what shall be the language of the union? There are so many languages right now. What shall be the language of the state? What shall be the mother language in this, all this? Then emergency provisions. Okay, what if, when, what will happen when there is some emergency involved in the country, when there is some external aggression, or when some natural calamity like coronavirus, this pandemic has come up, what to do right now? And then some miscellaneous provisions. Miscellaneous provisions are those when, out of doing all these things, still something is left to be done as per the requirement, it could be put in this particular part. Okay, so these are the indirect means to achieve those goals. These are the direct means. Okay, so now our constitution we have understood in a very detailed manner about the overview of what the Constitution of the India, and we have placed the Constitution of India successfully into 6 different groups. Group A is India, Group B is goals of India, Group C is means to achieve those goals, Group D is amendment if you want to make some change, Group E is interim and special provisions, Group F is introduction to the Constitution. Okay, so